Hello, once again, this is Antonio, and I'm coming at you with another exciting video. Now, this is going to be a pretty long case for the people that want to stick along and look at it. When I drop this fiery content, you definitely going to have your eyes bulging out your head. It's not for the weak. It's some strong content in here, strong history that happened between the stepdad and the stepchild. It's very vulgar. Of some of the testimony that took place. All right, so before we dive into the video, my name's Antonio. We drop heat over here. Make sure you subscribe to the channel, hit the notification bell, like this video. The more likes we get, the more it gets into the YouTube universe. Also, you can support the channel through Cash App and Super Chat. So nevertheless, that's enough of me rambling, and let's dive into the content. Judge Simpson, he gets fiery in this case. So let's dive into it.
Do not do that again.
Response to objection?
Do not do it again. You know exactly what I mean.
They spell your first last name.
Okay. Ma'am, I'm just going to have to ask you, if you would, just make sure to keep your voice elevated if you could. All right? Thank you. You may inquire.
Good afternoon, Ms. Daniels. How are you? So you can see that there is a microphone in front of you that's not going to amplify your voice, but we are recording it. So you just got to make sure to keep your voice up and an audible answer. So no uh-uhs or uh-uhs or anything like that. Is that okay? Okay. Ms. Daniels, how old are you? And what is your birth date? Are you familiar with the defendant, Carl Hearns?
Yeah.
Okay. And how do you know him? He is your stepfather or was your stepfather? Was. Okay. Do you see him present in the courtroom today?
Yeah.
Okay. Can you tell me and the judge where he is sitting and what color he's wearing? Okay. And can you audibly tell me where he's sitting? Okay. Your Honor, may the record reflect that the witness has identified the defendant.
Without objection, record shall so reflect.
Okay. And you said he was your stepfather, so he was married to your mom? Okay. Do you remember how old you were when they got married? Okay. And when they were married, did you all live together?
Yeah.
Okay. Where did you live together? Okay, is that in Ypsilanti? Is that in Washtenaw County? Okay. And did something happen with the defendant that brings you to court to testify today?
Yeah.
Okay, can you tell me what happened?
I'm going to have to speak up, young lady.
Can you repeat what you said? Okay. Can you tell me what you first remember about that?
It was an incident. I got in trouble. And he basically getting on it.
Okay. I'm going to take you back a little bit. Do you remember how old you were? Okay. And was this at the house in Ypsilanti? Okay. And you said you got in trouble. Do you remember why you were in trouble? Talking to a boy? Okay. What do you remember about where you were in the house when this happened? Okay. That, just talking to you about that first incident that you remember. Okay. And what do you remember happened first?
It was a brief conversation, and then he told me to get out and
Okay. And when you say give him head, can you tell me what you mean? Okay. So did part of his body go into your body?
yeah.
Okay. And do you remember if he said anything during this? Okay. And how long do you remember it lasting? Okay. What happened when it stopped? Okay. Was this the only time that something like this happened? Okay. Can you tell me about other times you remember?
You're going to have to speak up here, Lynn. Okay?
I'll tell a little detail. Sorry. It was just on my room. Like initiation, starting conversation, watching people or whatever. About foreplay, fingering, or it was a time of penetration.
Okay. So this time in your room, was this, do you remember close in time to that first time in the kitchen? Okay. How old do you think you were?
Probably maybe 11.
The first time? So this time in your room, was this, do you remember close in time to that first time in the kitchen? Okay. How old do you think you were?
Probably maybe 11.
The first time?
12.
Okay, the first time in the kitchen or the first time something else? Okay. I'm going to ask you some follow-up about that. So you said you were watching a porn video. Okay. And how were you watching that?
On the phone.
Okay. On defendant's phone? And what do you remember happened next after you watched the video or while you were watching the video? Okay. When you say fingering, what do you mean?
Like his finger on me.
Okay. His fingers in what part of your body? Okay. And you said that oral happened? Okay. How can you describe that? Is that what happened? Okay. So what part of his body was he using? Okay. Okay. And what happened after that? Okay. When you say penetration, what part of his body are you talking about? Okay. And this was when you were around 12? Okay. I'm going to take you back a little bit to the first time that there was oral penetration in the kitchen. Did anything happen between when you were 10 and 11 and that happened and then when you were 12? Okay. What types of things would happen?
Conversation.
Are you looking for an easy way to view and manage your mail and packages from anywhere, 24/7?
Okay, so when you say oral, the defendant would have you perform oral sex on him? Okay. And how frequently would that happen?
Like a few days out the week.
A few days out of the week? Every week?
Maybe, yeah, every week, maybe 2.
Okay. Now, when you were 12 and the penis to vagina penetration happened, was that the only time that happened? Okay. How frequently did that happen?
A lot of times.
Okay. Would you say more than 10? Okay. Would you say more than 20? And the location where this would happen, where would it normally happen? Your room? Okay. During this time period when it was happening, did you ever tell anyone? How come you didn't tell anyone? Okay. And did this contact with the defendant ever stop?
Yeah, I mean, on my bed.
Okay. How old were you when they got divorced?
14, 15.
Okay. Do you remember the last physical contact you had with the defendant? Okay. Can you tell me about that?
We had an apartment. I'm not sure. Exactly where at. By Easter or something. And I just remember thinking back on the office. It wasn't mutual. That was the last.
Okay. Do you remember how old you were then? 14, 15. Okay. So your cousin dropped you off, and what happened with the defendant? Okay. And again,
Excuse me a second.
Yeah.
You may want to mute that microphone unless you want everybody hearing that conversation. You have to hold down the button, counsel.
Yes, Your Honor.
Go ahead.
when you say penetration, which part of his body was he using? Okay, and where did that go? So would you say that this sexual contact with him happened on a relatively continuous basis from when you were 10 to 11 to when you were 14 to 15? May I have one moment, Your Honor?
May.
When these interactions would happen with the defendant, how did they typically start?
It's random, like maybe like a bill or coming in the room or something.
Okay. He would come into your room? Okay. And did you say a feel?
Of a guy,
He would touch you there? Okay. Would he say anything?
not exactly. Maybe like a comment on E or something.
Okay. What types of comments do you remember?
Or my body shape or
Okay. And when you were at the house and these things would happen, would you normally be alone in the house with him? Okay. Who else lived there at the time? Okay. And they would not be at the house? Do you know where your mom would normally be? Okay. No further questions, Your Honor. Thank you.
Cross-examination.
Ms. Daniels, when your mother married Mr. Hearns, and she moved in that house and lived in the house with you, correct? Said yes. Mr. Hearns worked as well, correct? Your mother and you were close when you were growing up as a child, correct? And your mother would take you to the doctor regularly, correct? Your mother would also ask you whether or not anybody was touching you inappropriately, correct? As a matter of fact, you consistently, repeatedly told your mother no. Your mother and Mr. Hearns wound up getting a divorce, correct? They got a divorce because of allegations that Mr. Hearns had been unfaithful to your mother, correct? Okay. During the divorce, your mother and Mr. Hearns were not getting along at all, correct? Okay. And during that time, you never told your mother that Mr. Hearns had done anything inappropriate, correct?
Yes,
Okay. About 4 years after the divorce, you and your mother still lived together, correct? The first year after the divorce, you never said anything to your mother about Mr. Hearns doing anything inappropriate to you, correct? The second year after the divorce, you never said anything to your mother about Mr. Hearns doing anything inappropriate to you, correct? The third year after the divorce, you didn't say anything to your mother about Mr. Hearns being inappropriate with you, correct? The fourth year after the divorce, you didn't say anything to your mother about Mr. Hearns being inappropriate with you, correct? About 4 years after the divorce, you and your mother were going through an eviction, correct?
yeah.
Right. At that time, your mother, and you were an adult at this time, correct? You were over 18?
I just hit it.
Yep. Your mother was struggling to pay rent. You were unable to help out?
Yeah, no, I'm gonna object as to the relevance.
What is the relevance?
The financial motive to lie, Your Honor. What winds up happening is my client allows him to move in with his mother and then puts him out. And then, well, you asked for the objection.
No, you address me, counsel. That's the way we play it here.
Your Honor, I am addressing.
No, you address me.
I am addressing the court, Your Honor.
Do not do that again.
Respond to an objection.
Do not do it again. You know exactly what I mean.
Your
Don't
Honor.
play with me. You know exactly what I mean. Objection is sustained. Next question.
You didn't make any complaint about Mr. Hearns until after he put you and your mother out the house, correct?
say anything to my mother. Someone else told my mother.
Right. After Mr. Hearns had put you out the house. Okay. You were living with Mr. Hearns' mother, correct? He told you to get out. Okay. And at that point, you had nowhere to go. And then these accusations were made. No further questions, Your Honor. Financial motive to lie.
I don't know what that is, but not here. Any redirect?
No, Your Honor. No redirect, and this witness may be excused.
Yes, you may step down. Additional witnesses for the people.
I have no further witnesses, Your Honor. People rest.
All right. Any witnesses for the defense?
No, Your Honor.
Motion.
Your Honor, I am moving for find over on counts 1 through 4, and I am also going to move to add counts 5, 6, and 7, criminal sexual conduct in the third degree, person 13 to 15. That is PAC code 750.520D1A. So that would be counts 5, 6, and 7. You heard from Ms. Daniels that the sexual contact began when she was 10 to 11, when the defendant made her put his penis in her mouth. From there, that continued regularly. She was around 12. He put his penis in her vagina, put his fingers in her vagina. She said that the penetration of the penis to vagina penetration happened more than 20 times, and that this happened on a continuous basis from when she was 10 to when she was around 14 to 15. I believe I have shown by probable cause that counts 1 through 7 have happened and that the defendant committed them, and I ask to find those counts over.
Response.
And I ask the court to dismiss the complaint against my client or her testimony, which the complainant witness alleged that numerous times while living in a home with her mother, she was sexually assaulted with my client. Nobody ever saw anything. She never reported it. She went to the doctor. The doctor never saw anything. And these accusations did not come up until 4 years after the divorce, after my client put her and her mother out of his mother's home. Yeah, we asked the court.
Those in terms of motivation and other things are if anything, factual issues which need to be resolved by the finder of fact. Have heard the testimony, find her testimony to be credible, and would bind the defendant over on these 4 counts as stated, the 7 and the added 3 counts. Quite frankly, the court is of the opinion that the court should add probably 10 counts based upon her testimony, but will decline to do so at this time.
Yeah, I'm here for PCC. The court said it would respond after the examination.
Defendant is therefore bound over to circuit court on counts 1, 2, 3, 4, and the added counts 5, 6, and 7. Yes, as to bond, but you need to do the circuit court arraignment, counsel.
Wait for more reading and standing. Yeah.
Defendant having waived formal reading, standing mute to all 7 counts. Court will enter a not guilty plea. I'll set pretrial after the bond argument. Go ahead.
As indicated at the examination, this case was previously dismissed against my client as polygraph. That's polygraph regarding everything that was testified today, including the additional counts. The court can look at those polygraph results, although they're not admissible in trial, they're admissible in evidentiary hearings, sentencings, and bond arguments. The police gave him a polygraph about these actions.
I don't have the poly. You're saying I can look at them, but I don't have them.
Briefly, I'll obviously let him continue his argument, but briefly, I actually do need to amend counts 1, 2, 3, and 4, because they're incorrectly charged as defendant under 17, and they need to be obviously defendant over age 17.
Pardon?
The counts 1, 2, 3, and 4 currently on the complaint are charged as first degree person under 13, defendant under 17. That needs to be defendant over 17.
Over 17. Got it.
And I can give Your Honor that PAC code, and I will obviously draft and sign an amendment.
All right, very good. Okay.
Your Honor, I'd like to quote directly from the police report. Upon completing my examination, I determined that Mr. Hearns had been truthful in his responses to the 12 test questions.
Are those the poly results?
No, they're not the poly results, Your Honor. They're the police report in which the detective of the case verifies and confirms that Mr. Hearns passed the polygraph.
Right, okay.
The court's shaking its head as if the court doesn't.
No, do not,
But
counsel.
he had
Counsel, I asked you for the results. You said I could take those into account. You read from the police report to me. That doesn't, where are the results of the poly? Did you get those?
Yes, Sean, I have.
Is there a reason, if you're asking me to consider them, I don't?
I did not print out the results of the polygraph questions and answers, Your Honor, but nobody's disputed like we were here yesterday. I mean, not yesterday, when we were here for the PCC, nobody disputed that he was asked these questions. He said no, and he passed.
Your Honor, it is correct that this was authorized previously in 2016, and it was dismissed at that time. It was recently reauthorized. Mr. Hearns also has another pending CSC case at circuit that is more recent, and that was part of the reason that this case was also reauthorized. This
Not against this victim.
no,
Somebody.
correct.
All right.
A victim who was also child of a woman that the defendant was living with at the time, who in that case, she is an adult with developmental disabilities. And he was bound over in that case, pending.
For the record, he offered to take a polygraph on that test too, was not given.
I do not have that information. If he wants to take a poly, he can take a poly.
Why? He took a poly on this case, they dismissed it and brought it back. So at this point, why should he submit himself to another polygraph examination? Because passing them, they're doing it.
He does have a statutory right to a poly, but that it doesn't require me to just based on the results of the poly.
Given the testimony and the added charges, quite frankly, I don't think the bond is set appropriately. I think it's quite frankly too low, but I won't raise the bond. A continuous bond motion for bond reduction is denied. Pretrial will be set.
July 10th at 1:30 before Judge Conlon.
July 10th, 2024, 1:30, Judge Conlon. Court calls the cases of the people versus Michael Deshaun Kyle. He's in. Very well. Do we know what it is?
Discharge TV.
That's what he's putting.
Yes, and the second case.
Oh, just one counter deviation. Okay. Whose case was that one?
You see, that one is Brown.
You come on up. I think we're taking a plea. All right, counsel. Court does call the case of the people versus Kyle.
Ready in those matters, Your Honor. Lauren Brown, Deputy Chief Public Defender, on behalf of Mr. Michael Kyle.
Deborah Geraldine Bledsoe Ford, attorney for Mr. Kyle.
All right. Pardon?
Our case is
12212.
25 years or so.
All right, what are we doing?
I offer that the defendant can plead no contest to count 3 domestic violence case number 24F1212. Upon a successful no contest plea to that domestic violence count 1 and count 2 in that file will be dismissed, and case 24FB1225 FY will be dismissed as well as part of that plea agreement. There are no further agreements, and that should be everything.
That is our understanding, Your Honor. Later at the appropriate time, we'll be asking for furlough for my client as his grandfather passed.
Certainly you can ask, and I will just say this. I've been dealing with a couple of furloughs from your office. I thought we had a criteria laid out, so I hope I have all of the criteria laid out so that I don't have to deny it because I don't have everything that I would need, but we can go through that. I've just indicate that.
We just found out about it, so I'm pretty sure you don't have.
I won't have. Okay.
His grandmother did call me though and advised me that the funeral is Saturday, this Saturday. that he had passed and that the funeral is this Saturday.
Okay, but what I'm indicating is that I'm going to need certain information before I would even consider granting it. I have a criteria for the granting of the furlough, so.
Just to make matters worse and more complicated the way that I like to, the defendant also has a hold from Jackson County for a violation of probation there. So even if your honor were to grant it, I don't know if that would just make him eligible for Jackson County to come get him.
Got it.
I don't think furloughs necessarily act as that, because the way other counties get possession is that.
Yeah, but we don't do anything like other counties.
Sorry.
We don't do anything like other counties. We do it right here in Washtenaw, so I don't know.
So,
all right.
Relinquishing the claim on filing him out.
All right. Okay. So that was a correct statement of the agreement, counsel.
Yes.
Yes, Your Honor.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I did. State your name.
Michael Cobb. Sir, it is this court's understanding that you're going to plead guilty or plead no. Is it no contest? Yes, no contest to the charge of domestic violence.
The reason for that is potential civil liability.
Thank you. That is a misdemeanor. It is punishable by up to 93 days in jail, up to a $500 fine plus court costs. You understand that, sir?
Yes.
All right. You also understand what a no contest plea is? All right. Let me explain two things about it just to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that? Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, you still wish to plead no contest. And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
I do.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes.
Bless you. You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
Yes.
Were you on probation or parole at the time of this offense?
Yes.
You understand this could be considered a violation of that. You were on probation?
Yes.
Okay. It could be considered a violation of your probation. You understand that? You understand that if it is considered a violation of your probation, you could be sentenced to the maximum allowable under those other charges.
Yes.
Has anybody promised you anything to get you to plead to this charge other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
The court has been provided and has reviewed Washtenaw County Sheriff's Office report for their case number 2422181. Any objection to the court having reviewed that report?
No objection.
Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this charge. Counsel, have I complied with the court rule?
The defense is satisfied, Your Honor.
Satisfied, Your Honor.
People are satisfied, thank you.
Court will accept the defendant's plea of no contest to count 3. Counts 1 and 2 in case 1212 are dismissed, and the entirety, I guess, the one charge that is contained in the case ending in 1225 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
June 24th at 10 a.m. before Judge Washington.
June 24th, 2024, 10 a.m.
Yes.
10 a.m. before Judge Washington.
Your Honor, one further thing. My client has asked me to address the bond in this matter, understanding he does have a hold, Jackson. He's asking that he be allowed to have his bond reduced. It's currently standing But in this matter,
100,000 cash or 10%.
so it's asking that now that one case has been dismissed, the other has been reduced down to the DV first, a misdemeanor in this case, that the bond reflect that. It's asking that the bond be set in this case at 10,000, 10% allowed.
Response.
The bond does reflect that. When my office charged this case, we requested 100,000 cash surety on the strangulation case. Then when we charged the now dismissed witness interference case, my office requested another 250,000 cash surety. The fact that we've entered into a plea agreement does not take away from the fact that the police were called, a neighbor had to call 911 when they heard the victim screaming in her apartment. When the police arrived on scene, they heard what ended up turning out to be the defendant. They heard a male voice yelling and irate and confronting the victim about possibly cheating on him. The victim answered the door. The victim reported to the police that she was asleep and she woke up to the defendant strangling her. The police observed a bruise on her neck that was consistent with what she reported to them. She reported that after she was strangled, the defendant threw her to the ground, that the defendant took her phone from her, preventing her from calling 911, and that instead he put his grandma on the phone and him and his grandma told her not to call the police. This then dovetails into the very long forfeiture argument that Your Honor heard, I believe it was just last week, regarding the defendant's interference with the victim's presence today. Your Honor, the bond being incurred at $10,000 does reflect this is now a misdemeanor domestic violence case. And as Your Honor knows, she has a rule from Jackson County. Thank you, Your Honor.
Is there a 10% privilege allowed in the 10,000?
In this case?
Yes.
Yeah.
Oh, I'm sorry. Then
Yeah, that's okay. You did it Chinauza argument almost.
So what we're asking for is $1,000, 10% privilege on that.
What, a 10,000, 10%?
No, 1,000, 10%.
It's 100,000 right now.
Oh, okay. All right. So I asked
It's 100,000, 10%. It is set at 10,000, basically.
All right. So what I asked for was 10,000, 10%. And
It is?
that's what I asked for.
It is denied. I mean, I've considered everything. I've looked at it. I've read the police report. The bond is set, although it's set in an interesting way with 100,000, 10%. I might have done it a little bit differently with 10,000 cash surety. I think that bond is appropriate as it's set. So the motion for bond reduction is denied. Bond will continue.
Go ahead. So right now it's currently set at 10,000 cash assured,
No, I left it where it was.
which is 100,000. So 10%. Let's see these numbers. I got mad.
I know you went to Michigan, so you'll never get them. Let me talk to you. It's 100,000, 10%, which is 10,000.
Okay.
And I said, I would deem an appropriate bond in this case to be a 10,000 cash surety, which would in effect be the same thing if I were to do it that way, given the charge.
Thank you, Your Honor. Thank you for letting me go over the facts again, even though I forgot it was no problem. Thank you.
Yes, I recall it. And the furlough, I want to make sure I'm clear on that because where is I mean, there are ways of securing him if that were the case, but there's certain information certainly that I would need in terms of obituary, who it is, notice to the prosecutor of when you want the release, when the services are, who. I need all of that information to make that consideration. Doesn't mean I would grant it, but I would look at all of that.
My client can put it on the record. I don't have it physically, but he can put that in.
No. Certainly he could put it on the record, but I need it in writing that he's requesting the furlough because everything would have to be in writing.
So what we can do, Your Honor, is we can get that office, can get that information. He's going to call us this afternoon, give us that information. We'll send that both to the prosecution and to this court, and then the court can.
Right, and then I can make my decision on that.
And will he be allowed to contact his family so he can get that information.
Here's the problem. He might want to give you information to contact because his phone privileges have been revoked.
The charge has been dropped. Dismissed. That's the one that was
Privileges were revoked in the domestic violence case.
Pardon? They were revoked in both cases.
So given the fact that it's been resolved, we can do
No, because what ends up happening, the basis for the revocation and what added to the charges that got ultimately dismissed was his inability to use that phone properly as well as do other things. So I'm not giving that back to him.
I have an idea, Your Honor.
Okay. Yes, Colin, that's
The
good.
grandmother.
Go ahead.
I'm sorry, I'm
No.
sorry, but it is on point. The grandmother called me. She reached out to me. If I can get her name and number from him, then I can give the information.
Absolutely.
Okay.
Yeah, because
Chief, the end game, the goal.
I just want to say I do.
Yeah, okay, all right. That's what I thought. I thought there was a family member that contacted one of you.
She contacted us.
So we can get that information and we can see what can be arranged.
All right, we got it.
Okay, I'm not guaranteeing anything, but at least give me the information stuff to look at.
So if you give
All right?
Is that right? Look at him.
Thank you.
work, I think.
Your Honor, I'm going to step next door to Judge Malvo's courtroom. Sorry.
I'm sorry?
I'm going to step next door to Judge Malvo's courtroom. She's got her officer to take into custody. So I'm going to be over there to start.
Oh, she didn't have to, we could have just done it. If you had said lock Hughes up. We would have. This is Ms. Hughes?
This is who they're bringing out. It's a waiver.
Hold it. Real quick, there's a waiver. That's your case?
I got it. Oleski?
Yes.
Yes, got it. Waiver, straight waiver. Sounds great.
Why? You just want to leave? All right.
I really don't.
When she comes back, we're taking her in. Date and time set for preliminary examination. Are we ready to proceed?
That's correct, Your Honor. Date times up for preliminary exam. People are ready to proceed.
Okay, so you see how Judge Simpson behaved in both, one court, two court possessions, one courtroom, but nevertheless, but one of them, he got a little fiery. I think that first judge was just out. First lawyer was out of line. Second lawyer, he knew to tread lightly when you go at, saying the ruling of Judge Simpson. I would say this: when you go to court, make sure that you have enough money to get yourself out of the sticky situations. He did not deduce the bond is 100,000, 10%. So he need to pay $10,000 to get out of jail. And when you go to jail, one thing about life is going to keep going. It doesn't stop. Your grandma died. Now you got to beg someone to let you go to that funeral. But nevertheless, this is Antonio with Team Tiggio. Please like, comment, subscribe, as we'll be coming to you more videos in the future. And once again, we will see you in the next video.